Good morning, everyone. Perfect. Check 1, 2. Are we good on audio? We are. Hey, Pam. We can edit that out. It's the beauty of recording this. Actually, why would we edit it out? We're gonna have Pam strolling through. I want to thank everybody for joining us this morning. Waiting on our online participants to log in. Welcome to our folks in Tampa and Orlando. Thank you for joining us this morning. Hey, Angela, do you want questions to come in while you're doing the presentation, or you want us to wait till the end?
Your choice.
You're the one giving the presentation, sir.
Well, I'm not going to be able to monitor the questions.
And Vanessa and I will be able to tell you as questions come in as well.
They can come in as I'm doing.
All right, perfect.
I like interaction.
I agree. Thank you. I prefer that as well. All right, folks. Cool. All right, let's get this party started. Good morning. My name is Carlos Carrillo. I'm the Executive Director of the South Florida chapter of the Associated General Contractors of America. Thank you for joining us today, October 12th, for October 2022 edition of our safety session. As always, I want to start off by thanking our sponsors. Number one, I want to thank the team from Kelly Cronenberg, who are not only fantastic hosts, but they also lend us some fantastic guests for this event. So thank you to the team from Kelly Cronenberg, Cedric, Adriana, Patrick, the whole team for helping us set up. For those of you online, I can't show you our breakfast spread, but this place is awesome. So we really appreciate their hospitality, appreciate them helping us out during the pandemic, make sure that we were able to get out our safety messaging to you and to our members. I also want to take an opportunity to thank the team from Milwaukee, our title sponsors, the great Roger Flores. Where are you, Roger Flores? Come on up, Roger Flores. I want to hear about what you got. I think, are you giving away? Wow. Everybody loves Milwaukee. He gets applause. What are you giving away to all of our members?
So I got to all of them. Hey guys, good morning. I was talking to Carlos and I want to announce something for the AGC members. What Milwaukee wants to do is offer a buy one, get one in all our PPE products, including vests, gloves, lanyards, no helmets. Not yet, no helmets, but we can do something for you guys. So again, we're gonna be offering buy one, get one in our PPE products. So if you have any question, please come to us. Please come to Dario. Let's talk about it, and let's offer all the support that Milwaukee offers. Thank you.
So that's awesome. So I appreciate it. And I've got my eye on a set of gloves that I will probably end up buying. So thank you very much to the team from Milwaukee. Roger and Dariel are here in-house. So if you have questions, for those of you here in person, you can go talk to them. We will be sending a follow-up email once this session is up on YouTube. And in that email, we'll include information on reaching out to the folks at Milwaukee for your buy one, get one free deal. How long is that going on, Roger, for the month?
No, for you guys.
For the remainder of the year. Load up. All right. So I'll be sending that email out, and we'll include it in the follow-up emails as well. And I'll include that flyer in the email for you, so you don't need to worry about that. But if you guys want to send it out as well, just as a reminder, that'd be great. Thank you. Thank you. Hey, I also want to recognize a brand new sponsor that we have today. Sean Glenn, where are you? Sean, come on up. I want to introduce Sean Glenn with Universal Engineering. Their sponsorship is the reason we have such a nice breakfast spread now. So come on up and talk.
Hi, good morning, everybody. I'm Sean Glenn with Universal Engineering. We are trying to promote more of our safety services that we offer. We've recently brought on a former OSHA inspector of 25 years experience in the state, who is now part of our staff. He's available for consultation or any questions you guys might have. We do from toolbox talks all the way up to OSHA 30 training, and even train the trainer training if anybody needs any of that. Look forward to talking to you. I'll send everybody out our information. Please ask any questions you might, if we can help or assist. Thank you.
Thank you.
So I'm very grateful. Sean and his team have signed on to sponsor us the entire year. You'll be seeing some of their content here presented as well. So welcome to the family, Sean. We appreciate having you. All right. Today I have the privilege of introducing one of the partners here at Kelly Cronenberg, Angelo Filippi. Angelo has dedicated his practice to labor and employment law, and many of our members use Angelo as their attorney. Look, I don't need to look at the paper for this one. Angelo has always been very generous with his time and expertise with us here at AGC. He has been part of coming out to our sessions for several years. We even have from now and again our Ask Angelo series, where he basically sticks around and we pepper him with questions, saving you valuable billable hours, right? So, maybe 15 minutes of a billable hour. So I want to welcome Angelo up here on the stage. He's going to be talking about a topic that he knows very well and that is very important to us. His presentation is what to do when OSHA comes knocking. So while he comes on up, I'm going to set up his presentation. Please give a warm applause for Mr. Angelo Filippi.
Everyone. In addition to my labor and employment practice, I also have OSHA defense practice, and I work with some of you in dealing with OSHA, both during their inspection process and if citations are issued during the process subsequent to the citation being issued. And we're going to talk about how all that works. First, I guess, enter.
Just hit the arrows back and forth.
Arrows. You need glasses for arrows. Okay, so the first thing we have up on the screen, and I will go through with you, so you don't necessarily have to turn around. You can look at me or you can look at the screen. Either way is fine. I don't mind if you turn your backs to me. Okay, so we're looking first at the top 10 most frequently cited workplace safety standards during fiscal year 2021. The fiscal year for OSHA ends on September 30th. And so this is the most recent list of frequently cited workplace safety standards on top. And it's been on top for as long as I can remember, at least several years, are fall protection issues. The second one is a little skewed because respiratory protection generally hasn't appeared as one of the top 10 on the list, but it has in the last couple of years. That's because of the COVID issue. Okay, and so there was a requirement by OSHA, or OSHA put out guidelines that told us, what type of respiratory protection our employees should be wearing. And people got in trouble because they were using the N95 masks. And if you use an N95 mask under OSHA standards, you have to have a respiratory protection program. And so that's where that came in. But generally speaking, that's not one of their top cited standards. Ladders, scaffoldings, hazard communication, lockout, tagout, training for fall protection, etc. All of these, other than the respiratory protection, have typically been in the list of the top 20, probably over the last 10 years. And so in terms of your safety program, and when OSHA comes knocking, that's going to be what they're looking at primarily. And the top one, fall protection, has been one of their emphasis programs in South Florida for many years also. Okay. So oftentimes OSHA, when they come on site, let's talk about a little bit about what they do when they come on site. So OSHA comes, the inspector walks in. What's the first thing we do? Anybody?
Check everybody that is there.
Take a break. Right, take a break. Well, in essence, stop work. Stop work. As soon as you recognize the fact that there's an OSHA inspector on your site, you need to stop work. What else do you do first? What do you want to do with respect to the OSHA inspector?
Check the fees and inspect.
Make sure he's who he says he is. Right, and they're required to show you their badge. Take them to the trailer. Don't let them walk around. Take them to the trailer, bring them in, and what's gonna happen next? What is he required to do? Anybody know?
Have a,
Opening conference, right. And so what information do you want from that inspector during the opening conference? Fernando, what do you want to know? Huh?
Why is he there?
Why are you here? Exactly. What are the reasons why he can be there? Am I messing up your?
You do great.
Okay. What are the reasons he could be there? Accident, that would be obvious.
It was across the street or something. Referral.
He was across the street and he saw someone not wearing fall protection. Exactly. Complaint? Somebody raised a complaint about safety on your work site? Or you've been targeted. He just wants to do a comprehensive inspection of the work site, of your facility. Perhaps you have a machine shop and he wants to come in and look at the machine shop. He has to tell you which of those reasons for his inspection. And how does that help us?
understanding for the area that we has a question.
Exactly. If it's an accident, let's say, and that's the reason they've come on, there's actually a case in the 11th Circuit Court of Appeals here that says he is only allowed, or she, only allowed to visit that accident scene. And so you can refuse to allow him to move to other areas of your work site. If it's a comprehensive, or let's say he had his binoculars and he saw something. Take him to that area, and that area alone. Generally speaking, they're not going to expand the investigation on their own. These are government employees, okay? And they don't want to do anything that their boss don't tell them to do.
What about a drone?
What about a drone?
Can you use a drone?
To do what? To take pictures.
Yeah, and then come on, knock on the door.
I would tell them, no, you can't use a drone. They're allowed to take pictures, but again, you can constrain them to the area that is the scope of their investigation. So if it's an accident, they're only taking pictures of that area. If they saw a potential violation, they're only taking pictures in that area. Okay, they could if let's say they were across the street with the binoculars and they saw someone without fall protection, they'll take pictures of the area where that person was. They'll do some measurements to see, make sure it's over 6 feet. They'll check to see whether or not you have fall protection equipment on site. And of course, you always want to have fall protection equipment that looks like it doesn't have frays or, problems with the equipment itself. So you want to show them the right equipment. And that's it. I mean, that's really what they'll do. And when they're on site, yeah, go ahead.
Is anybody from OSHA here?
No. If anyone was, no one from OSHA is here.
Can
outside, ask the OSHA inspector how close, for example, let's say he saw somebody next to the edge without fall protection. To push, the officer to say how close he is, like, to give a number. Is it okay to ask, the person in order to, confront him in a lawsuit or whatever, to say, he said he's 4 feet, from the edge, and how accurate that is? I don't know if.
I'm not sure I'm understanding the question. You mean the person who actually was not wearing the fall protection?
Yes, let's say, somebody is near the edge, right?
Right, I understand that part. So,
Take a picture. Can I say to the officer, how close is he to the edge, according to you? If he says, oh, he's about 4 feet,
sure,
can I later
absolutely.
use that against him? Saying like, no, he's further back.
May I interject?
Yeah, go ahead.
Outside of OSHA, same as you, not OSHA, but an OSHA trainer and, whatever. I'm also private resident. So if anybody's doing anything outside, anywhere, you can take pictures and you can take notes of what they say. If they're indoors, meaning there's a window and the window's open, you can still, if it's closed, you can't. But if you take a picture from here to the expressway, there's no way you can tell how close that person is to be.
Well, that can
There's
prove my
no way.
point.
And a drone, no, can't do that.
No
That's
drones,
violating
huh?
airspace.
Okay, good, thank you. But let me try to expand on that a little bit. So when you have an OSHA inspector on site, you want somebody to accompany that inspector, preferably someone on your safety team, okay? And you want that person only to be talking to the OSHA inspector at that time. That person is going to walk around with the OSHA inspector. If the OSHA inspector takes any pictures, they're going to take the same picture of the same spot that the OSHA inspector takes a picture of. And if the OSHA inspector makes comments, they should make notes of those comments. And so, yes, later on, potentially, if there's some type of admission, it can be used. Yeah. Okay? But what's going to happen is he's going to write in his note, in his notes something, and if he says something different, then yeah, then it's going to be the testimony that is different in terms of what he said and when he said it. So it all becomes evidence, though.
The logic that I was trying to use is the same logic as the police with the traffic, When they say like, oh, you were going 90 in a 60 zone, and then challenge the machine, how accurate that is.
Right.
And credibility.
Yeah, I mean, these guys aren't doing forensics, okay? So he says the guy was 4 feet away, unless unless there's a lot of dust and he can see the boots where the footprints are, and he measures from there. That's not going to be good evidence that it was 4 feet away, okay? Particularly if he's from some distance where he's taking a picture. There's no way you can tell what the actual distance was. It could be 4 feet, it could be 5, 6, 7, okay? So, I mean, but the important part is you want somebody to be accompanying that person, the inspector, and kind of mirror him in terms of the pictures. OSHA only has 2 types of evidence, okay? They have pictures and they have statements that are made. And that's it. The investigator's observations are not necessarily going to rule the day if you contest the citation, okay? They're going to testify as to what they saw, but at the end of the day, what's in their notes, with the statements that were made and the pictures that they took are going to be the pertinent evidence on a contest of the citation.
And as far as you mentioned that their notes might be different to what we did, but those notes, actually, handwritten notes are also part of the discovery.
It's part of the discovery, absolutely. Absolutely. Now, sometimes they're going to claim deliberative process because there's things in the notes that they're recommending or they're giving to their supervisor, and so they won't disclose that. but in essence, that their notes of the facts that they observe are evidence. Yeah.
So in the drive-by or the accident scenario, you said that they were limited to seeing only, of why they're there. The other two whys, why they would be there, either you're targeted or, there's a complaint, are they not limited to that scene? They can go anywhere or?
Well, the complaint, they don't have to tell you who the complaint is from, but they do have to tell you the nature of the complaint. So if the nature of the complaint is that, there's no guarding on the source, then they're only going to be able to look at the source, okay? Targeting is different because they're going to come and they're going to want to do a comprehensive investigation, and they're going to want to walk the entire site.
There's no way to limit them to that.
No. No, if you tell them that's not, at issue here, or, we don't want you to walk the site, they're gonna come back with a subpoena.
Outside of that, Bill, or that.
You're good.
They're also allowed to take an employee, any employee aside, to ask questions.
Yes, and we're gonna talk about that, and how to deal with that. So the other thing that OSHA does is they ask for documents. Okay, and so they'll come back, and the first thing they're gonna ask for you, your 300s, because they want to see your safety record. They're gonna ask for, if you're the GC on the site or you have subs underneath you, they're gonna want to see the contracts. And they're gonna want to see your safety program. Okay, and what does that mean? Because it's very important when you respond to them when they ask for your safety program, that you have certain elements that are included within that program that you provide to them. And this is where a lot of employers have trouble. Because let's say, let's do a LOTO, that's easy. So you have a lockout tagout policy. Okay, and you provide them with your safety manual, and you say, in the safety manual is our lockout tagout program. Is that good? Is that sufficient? No, that's not your program. That's just your policy with respect to lockout tagout. Okay, your program includes the training that you provided your employees with respect to lockout tagout, what you do to enforce that, and what should we all have to show OSHA that we enforce it? Well, if there are any violations, well, first of all, you have to have a disciplinary policy. If you violate a safety policy, you're going to be disciplined. Okay? And third, you have to show that you enforce that. A lot of employers will come and say, well, I've never had a safety violation with respect to LOTO, and so there was no need to enforce it. Well, you should go a little further than that and see if you have any discipline that's been issued with respect to any safety violations, so that you can show as a general rule that you're enforcing. And finally, you have to have some type of monitoring, okay, as part of any safety program. So you monitor the work site by having inspections on a periodic basis, is what they want you to do. And that monitoring, along with a hazard analysis, if you can show them those two things, monitoring and hazard analysis, they're going to be much less likely to cite you. Okay, we get together with the people in the morning, we discuss what the hazards on the work site are, we fill out a form. Okay. Our safety inspector comes on the site 2 or 3 times a week, monitors the work site for the different hazards. As we all know, in construction, there are different hazards on a work site, depending upon the day, what tasks are being performed that day. And so one of the things that they look at when they're looking at these hazard analyses is it just a form and they check it off and they sign at the bottom, and it's just, I've got 200 forms and every single one of them is the same. It doesn't happen. He's being sarcastic. That's not going to impress them. So if there is some detail about what the hazards are on that particular day, okay, that will impress. And it will show as part of your program that you're monitoring the work site. And that's important to them as part of a full safety program. When you do the training, you need to have competent people doing the training. They look a lot at certifications. If you have people who are driving equipment, forklifts, whatever type of equipment you have, motorized, powered industrial trucks, that type of thing. They want to see that they're people who are utilizing that equipment, are certified to use it and have been trained. And they're going to want to see the operating manual, etc. Okay, so all of that comes within the compass of your safety program. And I'm not saying, you know, if you don't have that, they're going to cite you. They may cite you on training if you don't have the training element. But I will tell you that if you have all of that as best practice, it's a lot less likely that you're going to be cited. So they will ask for that.
Pictures with the actually groups doing that, you think that they're gonna be impressed?
Yes,
Would
absolutely.
we actually do that?
Absolutely. Absolutely. Anything that you can show them in terms of monitoring the site is going to be a plus for you in terms of their analysis. You know, a lot of times when I speak to Mr. Eastman after the citations have been issued, he's going to say to me, listen, Angela, these guys don't have any of this stuff. You know, and that's really why we're coming down here. You know, if they had all of these elements, I would be a lot less likely to put a rubber stamp on the citation. And, you know, and I would come back and say, okay, well, they have this, they have that, and they have this. And a lot of times that results in either a reclassification or vacating the citation. And some of you here know that they do vacate citations even after they've issued them. If you can show them that you have this type of program. The next slide has to do with accident inspection. Again, my first one is take notes, and that I already spoke to you about. You know, you need to take notes about what they say. That was a good point about, you know, the 4 feet. Take notes on what they're telling you. Take notes on the questions they ask, because a lot of times if you have a superintendent or and your safety person is not going to be able to make it, the superintendent walks around and they take notes about what questions are being asked of them. You as a safety person or you as or me as counsel will be able to determine what they're looking at, what they're focused on. Yeah.
There's something, and people are doing it, the safety person is not in the place, they have to work what is an hour, they're regulated to wait.
They consider it like a reasonable time.
Now,
Yes, the standard is reasonable time. No. Yeah, and they will give you some time to get your safety person on site. If I call them, they'll give me an hour and a half to get there. Yeah, absolutely. Absolutely. Oh, recording is different. You have to get their consent to record. It's unlikely they're going to give you consent to record. I don't know of any situations where they've done that. So you want to have a notepad. And take as much as you can. You know, it's not going to be, I mean, even if it's cryptic, anything is going to help in terms of understanding what they're looking for. And that's really the key here, is to understand what they're looking for when they come in to inspect, so you know how to react. Make sure they have a camera. Understand the plain view doctrine. That's why I was talking to you. The most important thing at first is to make sure you understand what the scope of their investigation is, and take them to that spot, because the plain view doctrine says that anything they see, they can then make part of the investigation. If they take samples, collect samples that they take, control access to employees and attend management interviews. All right, so now we're going to talk about employees. The interviews during a walkthrough should be brief. Okay, you can limit them. They should not be more than 5 minutes. You want to make sure that they're interviewing the best people. Okay, so if you have someone who's been there for a long time with your company, and they've gone through all the training, and they're articulate, that's the person you want to put forward.
Can you stop and interviewing someone else that they wanted to?
Absolutely, that person's not available right now. Yeah, yeah, I mean, you, absolutely.
They can interview him at a later point.
We'll make him available at some other time, but right now that person is unavailable. Okay, if management witnesses or supervisors or foremen are interviewed, you have a right to be there. I have a right to be there. Somebody as a representative of the company has a right to be in that interview.
I was in a training about this in North Carolina with Turner.
Mm-hmm.
And one of the things that was taught in the room was talk to your employees, you know, let them know about their rights, about OSHA wants to talk to them, and they feel like they are not the person to be talked to, they can refuse to talk to OSHA.
Absolutely, and there, if you look at the slide, even non-supervisory employees, you can tell them that they have the right to have a representative present, not to be video or audio tape, not to write out their own statement or sign the statement, to obtain a copy of the statement, and to examine documents that are the subject of the questioning. You can also tell them that they can refuse the interview if they don't feel comfortable. But you have to be careful there, really careful, because there's a fine line between telling an employee what their rights are and obstructing the investigation. So you have to be real careful about telling them that. And you have to frame it in a way as, these are your rights, okay? You have the right to do this, to do that, to receive this, to look at that. And you also have a right to refuse if you don't feel comfortable right now. But that's as far as you go. If you do that, again, I would say if you're going to do something like that, you should have counsel on the site, because you're doing that as the employer. OSHA may at some point say, hey, you were intimidating, coercing, putting them under duress, and so you were obstructing our investigation. So you got to be real careful.
I believe the question was, what if I don't want to talk to them?
If the employee says to you, what if I don't want to talk? You can tell them that that's your right to tell them that. Okay? Yeah.
No, I got a question. Now, you know, we're in South Florida, and we have other people with different languages: Spanish, English, Creole, Portuguese,
and how you get an inspector is bilingual. But he's bilingual, Spanish is not that great. So then he's gonna interview the person, or the person who speaks only Spanish. And then they're gonna translate it and they're gonna write the statement in English, and they're gonna give it to the employee for the employee to sign. What would do like this?
I'm gonna get them thrown out, those statements thrown out. As long as the employee is gonna say, in a deposition, I can't read English, then that statement's worthless to them. But you're right, I mean, there's a lot of issues there when you're dealing with a bilingual workforce and an investigator who is not bilingual. Number one, I will tell you from vast experience that OSHA investigators are not the best interrogators. They're not trained on how to ask questions. And so their questions tend to be very broad. And then they use statements very narrowly. He said this to me, or you said, or he'll just write, yeah, I was not wearing fall protection at the time when the guy was saying I was not near the edge such that I didn't need my fall protection. It happens all the time. Okay, so one of the things you can tell your employees is they have a right not to sign. Especially if they don't understand what they're reading. They also have a right to have the investigator, if they do understand, if the investigator is bilingual and writes it in Spanish, then they have a right to have it read to them, and they need to make sure that everything that they said is accurately on that. Now, as you know, oftentimes that still results in poor statements that sometimes hurt the employer's position. But again, I mean, that, then it's up to the lawyers to fix that later on. But that is a problem, has always been a problem. But as long as the one thing you want to do is limit the on-site interviews as much as you can, which you can do. You're an ongoing work site. People are working, or they need to get back to work. And so, can we arrange to have these people interviewed at another time, at your convenience, at another location? And that'll give you an opportunity, number one, to prep them for their interviews and to make sure that you have a situation where there's adequate communication between the investigator and the employee, even if it means hiring, and I've done this, I've hired interpreters to sit in on interviews with employees so that everything is taken down accurately. Okay. More often than not, the OSHA investigator, except for one or two, are going to allow that. Any other questions? All right, let's move on. After the interviews, you want to debrief the employees, because again, that's going to give you good information about what the investigator is looking for. The investigator at the end of their time, and they have 6 months to complete their investigation and issue citations from the day that the inspection is opened. They will do a closing conference, take notes, make no admissions, list any issues already corrected, because there's going to be abatement issues if they issue standard citations. But they will explain to you during that closing conference what their findings are. And so you want to take notes on them. Again, the citations must be issued within 6 months. You then have 15 work days to engage in an informal conference. Now, let's talk about a citation. What is a citation? There's two parts to it. Number one, there's a standard that's listed that shows what they contend you violated. Number two, underneath that standard is an explanation of why they think you violated that standard. And that's the part you really want to look at closely, because that's the part often where they get it wrong. And that's the part where you can often make an argument during an informal conference that they got it wrong, that they don't have the facts to support that they misdiagnosed the hazard that existed, because OSHA has to show that there was a hazard and that employees were exposed to the hazard. The other thing I wanted to talk about a little is the difference between a controlling employer violation and an exposing employer violation. And actually, there's three ways OSHA can cite you. They can cite you as an exposing employer, a controlling employer, or a creating employer. An exposing employer means that it was your employee that were the subject of a controlling employer means that it was not your employee, it was one of your subcontractors' employees, whether it be first year. Now, what's important about that is that there's a difference in terms of how OSHA has to look at whether a controlling employer has violated the standard versus whether an exposing employer violated the standard. If you're the controlling employer, you're held to a lower standard in terms of the monitoring of the work site. And oftentimes the controlling employer citations are based upon the monitoring of the work site, the failure to monitor adequately such that a subcontractor was allowed to diverge from the standard. A lot of times what will counter that will be, number one, that this is a subcontractor that you've used on many occasions. They have a perfect record. They've never had a citation, or to your knowledge, on any of your sites. And your contract says that they are required to train their employees and to monitor them. Number two, you as the controlling contractor monitor the work site. You have a safety person who comes on the work site periodically and prepares a report showing what issues in terms of safety have occurred on that work site. If you can show those two things, 90% of the time that citation is going to be vacated, because you're not the exposing employer, you're the controlling it. No questions on that?
So, to get it clear, sub would be the total employer.
Correct.
They're liable for their own fee.
Not just states that. You have to make sure that they're doing what's in your contract. Okay? They're training their employees, they're monitoring the work site. Just don't say subcontractor is responsible for complying with all OSHA standards. If that's the only thing you have in your contract, that's not going to be enough. There has to be some additional language that puts them or puts responsibility on them to make sure anyone who comes on your site is trained. Anyone, that they have a safety person who monitors the work site. And that, if they have a good record with you, or period, if they have a good record, because you can check their records easily on OSHA's site. All of those things together, all of those elements together negate what they consider the responsibilities or create a situation where you've met all the responsibilities as a controlling contractor under their guidance.
She said, we use lots of, and then always time my hand, I'm like, what's this up? On myself, whether it be not really kind of thoughts on
Mhm.
and I always get that they're responsible for their own program.
Right. But
I always document, put it in my report.
okay.
I feel like that.
All right, and so you have a report that comes out and you have a certain sub, and this sub is violating safety issues, not using the PPE, let's say, let's just stick on that. And that happens repeatedly. And you've done nothing about it other than putting it in your report. Not gonna look good. You find them. Gonna look better. After a third violation, you throw them off the site and bring in a new sub. Vacate the citation. Okay, now I'm giving you extremes, but you see what I'm getting at in terms, you can't just put it in your contract and say, this is it. You can't just do a report. There has to be consequences also.
Angelo,
Yeah,
should that, part of the safety, should it be a separate contract? To really stand out, or?
doesn't have to be, typically not. You don't want to have too many contracts out there. I think it's all should be part of the subcontract. And that's generally what I see.
To expand on my colleague's question, what about those subs and the subs and the subs? What can the GC or the government?
Well, there are two situations that I find with those issues. Number one, sometimes the GC isn't even aware that there's a second tier or a third tier on the site. Okay, and so that's their first tier's responsibility. Okay. In essence, the first tier becomes the controlling contractor for the second tier or the third tier. But as the first tier, you have to ensure that if they're bringing in second and third tiers, the same thing applies to the second and third tiers as applies to their first tier. Okay, if your contractors are not telling you that they're bringing in second or third tiers, you got a problem to begin with. You don't have no idea what you're getting in terms of skills, efforts, and responsibilities. Yeah.
The obvious, let somebody point it out to you. But in this case, if we were to go back and add a line item to the contract and say, you must produce history of training, history of citation for you, and if you were ever to bring a subcontractor under you, same rules apply.
Mhm.
I mean,
Good.
now you go.
Yes. As long as you do all the other things I was talking about, when there are problems.
So Angelo, that's a great question, one. Is there a place where the contractor can go to see citations that were given to a subcontractor that they're hiring? This question came online. Where can you check the OSHA records for the contractor or subcontractor? Is this public record?
Google the OSHA establishment site,
Okay,
and you can find any contractor on there that has a history with OSHA.
and that is OSHA establishment site, right?
Right.
OSHA.gov. Okay, great. Thank you.
After being issued a citation, you have 15 federal working days to engage in an informal conference and to contest the citation if you need be. The informal conference, you'll typically meet with the assistant area director or the supervisor and the investigator. And you can talk about evidence. Again, though, anything said in there is evidence. The purpose of that is to try to resolve it. And so you have different issues that you may want to address. Number one, was there a hazard? Number two, what is the evidence of the hazard? Number three, what is the evidence of the person violating the standard? And number four, how am I responsible as a controlling contractor here when I've done all of these things? Okay, those are legitimate questions in an informal conference. And then it's just like any other settlement negotiation in which you have certain goals. If your goal is to vacate it, then that's your goal. If your goal is to get the reduced from a serious to an other than serious category of violation, and that's a goal. What is a serious violation? A serious violation means that there was a substantial likelihood of serious bodily harm. And other than serious means that there was not a substantial likelihood of serious bodily harm. And that may be important. Why? Because you may have, if there was an accident, you may have potential liability issues in terms of a suit for the injuries, or a suit outside of workers' comp for the injuries if you're found to be grossly negligent, or a suit for wrongful death if there was a fatality on the site. And so that's a consideration in terms of getting it moved from one category to another. Also may be a consideration if you're bidding on jobs where you have a developer or builder or whatever it may be, an owner who has a strict policy that they will not hire contractors who have certain types of OSHA violations or certain or any OSHA violation. So that may be a consideration of what you want to do in those negotiations.
Angela, should you be there for the informal?
I'm there for every informal for my clients, yes.
Good idea, right?
Yeah, and for many of my clients, I'm called to the site when the OSHA investigator shows up. I'm part of the rapid response team. It's a real thing. I'm not kidding. Yeah. Don't know how I got on it. I just anointed.
Reputation, buddy.
No.
No, I'm not proud of it.
There was one situation where there was an accident on 95 where, you know, they're doing the night work or 595, and I got called late at night. And I went on site. It's a lot of fun going on site on 595 in the middle of the night when the cars are flying past you. Anyway, so I have on this slide the reasons to contest. The citations are unsupported by the facts. The expense and the potential exposure to repeat or willful violations. Repeat or willful violations, as you know, substantially increase by tenfold the potential penalties. And once you get a willful or a repeat, I guarantee you have a target on your back. Yeah.
But I have seen a case or two, you know, where it has been almost like 10 years between both violations, and they were considered repeat.
5 years.
5 years only?
5 years. A citation remains on your record for 5 years, and under under the law, you cannot be charged with a repeat once that 5 years has expired.
What about those set aside states? If they say 10, you have to.
Yeah, you know, I'm dealing with one in Nevada now, which is a set aside state, and I do think they can use their, I think they have 10, and here they can use the 10 as a repeat, so. Yeah, but I mean, here in Florida, we're not, so not an issue. 5 years here in Florida. So, if you don't successfully negotiate at the informal conference, you have a right to contest. A contest is before an administrative law judge, in which it's just like a bench trial where you present your evidence and they present their evidence and you make your argument, and the judge decides whether or not the standard holds. Okay. The reasons why, again, you would want to contest is, do the citations have implications for a civil suit? And many times where there's an accident, it does. Are the penalties excessive? But for the most part, with my clients, penalties aren't the issue. It's the citation standards themselves, the exposure to repeat or willful violations, and that the fact is that the citations are unsupported by the facts. And they get it wrong. You know, they have investigators, they investigate and they cite a particular standard, and oftentimes they get it wrong. They just plain get it wrong. So, you know, if I can't convince them of that in a informal conference, then I will convince a judge of that if they've got it wrong. All right, the remainder of the slides have to do with reporting. I presume all of you know that reporting is, you know, if you have a fatality, you have to report within 8 hours. If you have an accident that involves a hospitalization or an amputation, you have to report within 24 hours. If the only caveats to that is if the fatality or the hospitalization occurs more than 30 days after the accident, you don't have to report. Okay. And I think my time is about up. Yeah.
The two fusion company trucks.
If they are, when you say to from, are you talking about a commute, or are you talking about they're going to pick up materials?
They go to the yard, they refuel, they're driving to the work site an hour away,
Reportable.
they're involved in an accident, maybe one died in a crash.
Reportable.
Outside of the home to zero.
Not reported.
It's plugged in, right? They said company time.
Any other questions?
I got one, Angelo.
Yeah.
How many subcontractors are here? Nobody on these? The question is, if a subcontractor worker gets hurt, OSHA automatically gets called because of the police or somebody else called it in. First interview, they go through it, they got it done. Later on, it finds out that the subcontractor decided not reporting it to OSHA, even though there was an interview by OSHA done. Is that subcontractor have a way out, or he does have to call OSHA himself?
I would argue that they have a way out. I mean, if it was reported, it was reported. There's no need to juggle reporting. I'm not sure why OSHA would cite it in that situation. You're talking about simply because one contractor didn't report when it was, and you're talking about the exposing contractor? Technically, they should report, and technically OSHA can cite them. Would they do that? I'm not sure.
But does the GC have a responsibility to call? I think no.
The GC have the ultimate responsibility to report if there's a fatality on the site?
The subcontractor. Has fatality on site.
No. Agree.
Or any other issue that would require notification. What I've done is I give them all the information. Here's the contact information.
Cool.
It's,
Yeah,
now,
that-
now you're willfully not doing it.
I agree. That's probably the best way to handle it.
So I had a case where the department got cited for not following OSHA after they already had 2 meetings with OSHA after the incident. That was with the actual citation run.
Really?
So I thought they did. No,
What office was this?
it shouldn't fall down. They call me after the fact also, so.
No, what OSHA office?
From what there?
I would have made a call to Condell, said, what are you kidding me? Any other questions?
No.
Thank you all.
No, thank you. Appreciate it. That was fantastic. I love how furiously everybody was taking notes. So, you know, that shows you that is very high level content. So thank you to Angelo. Thank you very much to the team at Kelly Cronenberg again for having us here, for allowing Angelo to present. I also want to thank the team at Universal Engineering. Welcome. Welcome to the safety family. I also want to say thank you to Milwaukee Tools. Don't forget the buy one, get one free offer that's going on. Everything except helmets. We got you. Also want to thank the members of our safety committee, Deborah Hampton, Ian Schwartz, Jose Bobadilla, Mark Leon, Enrique Sequeira, Brian Cardona, and Kevin. Kevin, who left early with Gulf Construction. He had to get to a job site. We appreciate you, Kevin. I'm looking forward to seeing you all next month. Just a reminder, we have some great events coming up. Our wine event is tomorrow. It's too late for you to get a bottle of wine, but you're able to join us. If you're interested in what's going on federally, we're going to have AGC's Vice President of Government Affairs with us, and he's going to be discussing the midterm elections and what the potential ramifications are of those elections. In 2020, he was completely on point. I have a feeling he'll be on point again in 2022. You can register online at floridaagc.com. That is a brand new website, floridaagc.com. And I look forward to having you register for that. Your young professionals will be having a YCF, the Young Constructors Forum event at Top Golf in Miami Gardens the following Thursday. If you guys need any information, our website's a great place to start. If not, you can reach out to myself or Vanessa, and you'll see our information on the follow-up email. Thank you very much for joining us. Don't forget to tell your friends and colleagues about what we're doing here and to check us out on YouTube. All of our safety sessions are on our YouTube page. Jump on YouTube, look up South Florida AGC. We will be there. Make sure to subscribe and like your videos. Thank you all very much. Have a great day. Bye-bye, folks.